Good afternoon. My name is Edward Stone, and I'm special counsel for the Association of BellTel Retirees. I've been involved with the association for close to 10 years now. My original involvement started when all of a sudden folks learned that 41,000 Verizon retirees were being kicked out of the Verizon pension plan, and they landed in the laps of an insurance company as certificate holders under a group annuity contract. And that's somewhat of a new phenomenon known as pension derisking or pension risk transfer. I'm going to talk to you today about what that all means and what the association has been doing about it over the past several years. So if we go to the first slide, we talk about what pension derisking is. Pension derisking is any decision by a defined benefit plan sponsor to get rid of pension liabilities. Those types of decisions can take a number of forms. It can be a change in investment strategy. It can be the purchase of an annuity contract inside of a pension plan. It can be offering lump sum benefits to certain retirees. But what's most relevant for the association members is what I call a pension lift out, where a defined benefit plan sponsor purchases an annuity contract but kicks you out of the defined benefit plan and you default to state law. So the next slide talks specifically about that, and that is pension derisking involving an annuity contract purchase. So as I had mentioned at the outset, in 2012, Verizon essentially kicked 41,000 retirees out of their pension plan, and they transferred all of the payment obligations to Prudential Financial. A Verizon subsidiary purchased an annuity contract, which is a group annuity contract. And this was kind of a unique transaction. It was one of the first times ever where a defined benefit plan sponsor amended its pension plan to get rid of retirees. Termination of a pension plan has been a common practice over the past century or so. Companies go out of business, they terminate their pension plan, and they transfer all the obligations to an annuity contract, but everybody gets treated the same. In the case of the Verizon retirees, there were approximately 100,000 retirees who were covered by the plan. 41,000 got kicked out, and some number greater than 50,000 remained. So it's a very unusual transaction in that some people who were beneficiaries under the plan were still in, and some were kicked out. That led to a lot of litigation, but unfortunately, the Supreme Court has ruled that if you can't show current economic harm, you don't have standing to bring a lawsuit under Article 3 of the United States Constitution. And this holding, which came up in this case, which the association took all the way to the Supreme Court through the great work of Curtis Kennedy, has reverberated, and the Supreme Court has even doubled down. In a recent case involving a U.S. bank matter, Thole versus U.S. Bank, the Supreme Court said even when you see what looks like a breach of a fiduciary duty, if no retirees get hurt, and if they can still get the payments in the future, you can't challenge the transaction. And that was subject to a lot of scrutiny, but right now the environment at the Supreme Court is very difficult for ERISA claims. In any event, insurance companies has been taking on more and more risk since the Verizon transaction. And as of June 2017, Prudential had taken on $400 billion just related to PRT. And as of May of this year, Prudential accounts for approximately 1/3 of all pension risk transfer business. Just for your own edification, pension risk transfer and pension derisking are really the same thing. They're kind of interchangeable terms. From the insurance companies, they like to talk about it as pension risk transfer. I always refer to it as pension derisking when I speak about it from the retiree's perspective. So the next slide speaks about why this really matters. What do retirees lose and why is it important? Well, first and foremost, retirees lose the uniform protections that were intended by Congress under ERISA. ERISA was signed into law in 1974, and it was designed to protect employees and retirees from abuses in the workplace. And it was designed to give uniform protections so that all retirees would be treated equally. Under ERISA protected pension plans, creditors can't get at annuity payments, can't get at pension payments. All participants have ready access to the federal courts. All fiduciaries, all control parties are held to fiduciary standards. As some of you may recall, when this was a defined benefit plan, you would get an annual statement with detailed financial disclosures. With a group annuity contract, there are no disclosures whatsoever. And finally, and perhaps most importantly, retirees lose the benefit of the Pension Benefit Guaranty Corporation coverage, which provides a monthly benefit that increases as a function of age. Unfortunately, now retirees default to state law and state guarantee association coverages, which are not uniform and for the most part unfunded. So the next slide does a little bit of a comparison between a defined benefit plan pension that's federally protected and a group annuity contract that's governed by state law. I think the most important issues are really uniform protection from creditors under ERISA, detailed annual statements. It's good to know where you are so you don't find out too late in the game that there's a problem. Very important as well is the fact that the defined benefit plan sponsor is a fiduciary, and under ERISA is supposed to act in the best interest of plan participants. That's very important because the insurance company has no such fiduciary duty. And then the PBGC provides a lifetime of monthly payments in the event that the employer goes under. And a lifetime of payments is very important because nobody really knows how long a retiree is going to live. And not to be crass about it, but state guarantee association coverage is per individual per lifetime. And so folks who live longer might not get anywhere near enough coverage. And folks who live a short time might get the same amount of coverage as they got under the PBGC program, but there's absolutely no way of knowing. And frankly, the way I look at it, payout annuities just don't lend themselves to this per individual, per lifetime coverage amount. Most states provide $250,000 in coverage. I use Massachusetts as an example. That's kind of the minimum that's in force right now. When we started this whole endeavor, by the way, it was $100,000, but many states adopted the NAIC guidelines and upped it to $250,000. There are a number of other states who have $300,000 in coverage, and there are 4 states that offer $500,000 in coverage. What's really important to understand about guarantee association coverage is that it's voluntary, and it's what I refer to as a post-insolvency assessment vehicle, which means that there's no real money in the guarantee funds. They get contributions and they make assessments of their members, and all of their members are insurance companies who write business in a particular state. And the amount that they can assess per year is capped. So there's only so much that a large insurer can actually tap to get coverage up to the amounts that are needed. So the bottom line is the best thing possible is under all circumstances trying to avoid an insurance company insolvency, particularly an insurance company the size of a Prudential or a Metlife. And the reason that these different regimes exist is because under the McCarran-Ferguson Act, all of the business of insurance is relegated to the states, unless there's a statute that specifically says, this is the business of insurance and this is regulated at the federal level. And that only happens in rare instances. Okay, so moving on to the next slide, which is kind of interesting from my perspective, is just, really, why do retirees need to care about this? Well, first and foremost, there are very few annuity providers in the pension risk transfer business. There's really only a handful. and there's hundreds and hundreds of billions of dollars at stake. Unfortunately, we all learned during the financial crisis that nobody is too big to fail. And just because a company appears to be large and look good on paper, there are a lot of things that can happen that could change that situation relatively quickly. And we've also learned, unfortunately, that more and more of the publicly traded life insurance companies have been engaging in very suspect financial transactions involving affiliates or captive reinsurers, where they're really just moving risk around within the same family and not engaging in true risk transfer. And the reason that's a concern is because most of the pension payments that you folks are looking to receive are due over a long period of time. And by swapping reserves, which are hard assets, admitted assets, assets that a regulated company would be able to hold, for reinsurance contracts with affiliates, a lot of companies have been able to transfer risk to companies that don't have the commensurate assets to meet those liabilities in the event of a stress scenario. So to the extent that there was a stress scenario on a large publicly traded life insurance company, those IOUs that are due from affiliates might not be money good. To add to that, we've learned just through what's happened in the public markets about some servicing disasters involving group annuity contracts. One in particular involved Metlife, and it was really a disaster that led to them paying significant penalties to the regulators. But essentially, if you think through the whole process and you're somewhat skeptical or cynical, if they can't find somebody, that's found money, because they got a chunk of change in exchange for a promise to make payments. If they don't have to make those payments, they don't give the money back to Verizon. Essentially, they keep it. So it creates kind of a perverse incentive to lose people. And I'm not saying that's what's happening with Prudential, not at all, but it just creates the wrong incentive. And when you're looking at thousands and thousands of people and billions of dollars, you could see where that creates the wrong incentive. Okay, so the next slide goes into a little bit more detail about what actually happened with Metlife. So they bought a lot of different pension obligations. So it wasn't all stuff that was originated internally, but they forgot or neglected or failed to pay tens of thousands of retirees. Most of these were small payment amounts, but the payments were simply not made. And it was a long period of time that this went unnoticed. But the regulators found out about it through a series of disclosures and investigations, and they slapped Metlife with a very hefty fine. So did the SEC, and they apologized for doing it. And they said they were going to enact very significant new procedures to avoid this happening. But they also contributed more than $500 million to their reserves, which says something more was going on here. And basically the more was, because they didn't have those liabilities on the books, they were able to take the money out of the reserves and use it for other corporate purposes. Once they realized that they had been caught with their hand in the proverbial cookie jar, they had to make amends, and they had to not only pay a fine, but they had to put a lot more back into reserves to avoid further fines. In any event, right after they did this, business was business as usual. In 2018, FedEx did a huge deal involving $6 billion in pension plan obligations. Ironically, the number of retirees with FedEx was almost exactly the same as the number for Verizon, at least as published. It was listed at 41,000. Verizon was also listed as 41,000. And again, Lockheed Martin just transferred $1.9 billion to Metlife. So Metlife, even with the lost pension debacle, the fines, the contributing money to reserves, it still seemed to be a good place for folks to go to get off risk. Okay, the next slide kind of quantifies just how much business has gone on since I originally got involved in dealing with the association. So that number is not a lie. That's almost $160 billion, which, it's real money. And that's just in obligations transferred from 2012 to June of 2020. Now, I will point out that volume is going down. I guess with the pandemic and some changes to pension plan accounting as a result of the CARES Act, there hasn't been as much volume. The volume is significantly off, down by 50% lower than any quarter over the past 2 years, down to 2.3 billion in the third quarter. So I think, I'm sorry, second quarter. So I think that that's in part related to the pandemic, and it's also in part related to the fact that under the CARES Act, defined benefit plan sponsors do not have to contribute their minimum required contribution in 2020. So they have until 2021 to start making those minimum required contributions again. So it's kind of a funding holiday for defined benefit plan sponsors, which makes it less pressing for them to try and get off risk. Okay, so turning to the next slide, which is really what my efforts have really focused on over the past 8 years or so, and that is the need for state legislation. You know, as we talked about, post McCarran-Ferguson, the business of insurance is relegated to the states. As you can see by this colorful map, there's a lot of different states, and as you guys know from watching the news, we have a lot of different viewpoints on how things should be done and what's important. And so each state makes its own laws and has its own procedures for dealing with things like pension risk transfer. And so we've started a campaign in a number of different states to introduce legislation to replace the protections that were lost once a company de-risks. So the next slide will give you a little bit of background on what the Association of BellTel Retirees has been doing. The association has supported state legislation that provides protection of annuity benefits from creditor claims. Again, just replacing a protection that folks had under ERISA and lost. We're advocating strongly to limit subsequent transfers. What we're trying to do is prevent a solvent insurance company from transferring these payment liabilities to a less solvent insurance company. And we've been successful in at least one state, and we've gotten traction in a number of others, but this is a very difficult thing to do because it imposes requirements on folks. And frankly, it's something that people have never really looked at and don't always fully understand. We've also asked for mandatory annual disclosures. We believe it's important for retirees to be fully informed about what's happening with their pensions. Very often, insurance company lobbyists oppose disclosures of any type. Although they acknowledge that some could be reasonable, they haven't really signed on to this notion. And we would like to make all insurance companies fiduciaries with respect to retirees. We don't think that that's an unfair leap, since under ERISA, the plan sponsor was a fiduciary. We believe that the insurance company that takes on the commitment to make these payments to retirees through no choice of the retirees were never given a choice when their pension was de-risked. We think that the insurance company should be held to a fiduciary standard. Finally, I discussed a little bit about why I don't think guarantee association coverage makes sense per individual, per lifetime, capped coverage. That means if you have a life insurance company, a life insurance contract, and an annuity contract with the same carrier, you're capped. And if you have two annuities, you're capped at that per individual, per lifetime amount. And that we don't think is fair. So we've tried to introduce legislation to push for real reinsurance to cover the difference between guarantee association coverage and PBGC coverage. Now, this is kind of calling folks bluffs, because if there really was no issue with insurance companies making payments under these group annuity contracts, it shouldn't cost a lot of money for them to buy reinsurance to provide peace of mind for retirees. So that's where we'll see where the rubber meets the road, whether or not we can get that passed. But that's one of the things that we are trying to do at the state level. So that kind of summarizes the efforts of the association when it comes to pension de-risking. I'm proud to be a part of the first ever virtual annual meeting, and I can be reached very easily, either directly or you can contact the association and they'll reach out to me. And I thank you very much for the opportunity to present to you. And I wish you all a safe and healthy remainder of 2020.